Business ownership sometimes complicates divorce because it becomes an issue for equitable distribution. The court often looks to certain questions, such as the timing of the business formation. For example, if the business was formed prior to the marriage, it usually is treated as individual property and not marital property. However, if, despite the business being formed prior to the marriage, the other spouse contributed in any way, such as with labor, or the assets were commingled from the business with the marital assets, the court will look to this during a equitable distribution. Any efforts made by you, especially if it's your former partner's business that they founded before the marriage, are clearly documented and business valuations are kept up to date. A business valuation will be absolutely critical during the divorce proceedings, especially if both spouses contributed to the business, independent of when the business was formed. It's often necessary to have an expert analyze and perform a comprehensive business valuation that will cover certain things such as profit and loss. The goal of this is to ensure that a proper valuation is done of the business ownership interest, because in terms of equitable distribution, the court will look to this when determining what percentage of the business should be awarded to each spouse. Attorneys can assist, especially if one party is exercising bad faith. If you anticipate that your spouse will try to dissipate the assets or try to hide income or manipulate the facts in order to secure an advantage in divorce proceedings, an attorney can file a motion to prevent the dissipation of those assets, as well as very early on start the business valuation process so that your divorce is handled in a more expedient fashion, saving you time and energy, as well as financial resources. If you're a business owner, it's very important for you to have a prenuptial agreement in place. In New Jersey, prenuptial agreements can help business owners in several different ways. First, they can define how the business is classified. If the business is going to be treated as separate property, whereby you maintain 100% ownership, or it will be classified as marital property, in which your spouse can have a significant share over the ownership interests or business income. It can also explicitly define how the business is to be valued in the event of a divorce. And it establishes clear parameters as to who can maintain ownership during any divorce proceedings. It's also necessary to protect client relations and confidentiality. Without a prenuptial agreement defining these clear terms, you can spend years in litigation with discovery demands, and it can be quite stressful and affect how your business is run during this time, affecting your profitability and how your business runs smoothly. Just like business profits, business debts can also be a topic and defined very clearly in a prenuptial agreement. The court, absent a prenuptial agreement, will use equitable distribution in order to assess each party's ownership interests and each partner's ownership liabilities, especially if the business was run by both parties in some capacity. Even if the business was formed separately prior to marriage by one party, if there was sufficient assistance by the other party in business, the court can assess some liability to that other party. If you're a business owner and you are contemplating divorce and have questions, please give us a call at Next Chapter Family Law. We're here and we're happy to help.